employment law lawyer. Over the past couple of years, COVID has certainly presented a lot of challenges and interesting new issues for us to consider. And of course, one of the most topical ones right now is vaccine mandates in the workplace. So as is the case both in Alberta, where Tessa and I are resident, and in the NWT, the government hasn't mandated anything with respect to vaccinations in the employment context. There's certainly been vaccine passports and to access services and other types of public places and events, but there hasn't been any direction with respect to the workplace, and that's been left largely for employers to figure out on their own. So it's been a very complex and rapidly evolving area for us to try and keep up with as lawyers and then advise our clients accordingly. So KPMG actually did a poll back in August of 2021, which, you know, in COVID times really feels more like 5 years ago now. But at that time, the businesses that they polled said that about 62% of them were going to implement mandatory vaccination policies in the workplace. And that's, I think that number must be much, much higher now in practice. Virtually all the clients we work with have mandatory vaccination policies, as do many of the largest employers, certainly in the federal public service, so across the country, and then the GNWT public service does, Alberta's public service, Alberta Health Services, post-secondary institutions. So really large and major employers have vaccine mandates, and as do many of our smaller to medium-sized business clients as well. So all of this has happened really quickly for good reason. Everybody's trying to take the steps that need to be taken to keep everyone safe and help us in the best way possible to get over the pandemic. But at some point, we sort of have to sit back and look at, okay, we've put all these things into place, and what are the legal underpinnings that come with these policies, and what makes us, what do we need to consider, what allows us to do these types of things, and what do we need to consider, what are the balancing and competing considerations. So we'll talk a bit today about the legislative. So what pieces of legislation permit vaccine mandates, what are some other pieces of legislation that we need to factor in and consider when we're putting policies in place. And then the timing of this presentation today is excellent in that we've just had some recent case law come out about vaccination policies in the workplace specific to COVID. So these are arbitration decisions, but we do have some statements from arbitrators and tribunals about how we're going to handle some of these challenges. So that's really new, and we'll talk a bit about that today. Then we'll also address some policy considerations, things that you need to consider if you're going to have a vaccine mandate at your workplace. And then, of course, if you have a vaccine mandate, when do you need to make exemptions for it and on what basis? And that's largely a human rights consideration. So we'll talk a bit about that as well. And I should say as well, we'll try to leave some time for questions at the end, but we're also very open to any questions just being raised during the course of the presentation. So feel free just to either unmute and ask a question or to put a question in the chat, whatever is the easiest. So just starting with the legislative landscape, there are no laws, of course, in Canada or in the NWT that mandate everybody to get a COVID vaccination. So we don't have that kind of overarching legislation. But when we look at vaccine mandates in the workplace, the key piece of legislation that really is driving these types of policies is workplace health and safety legislation. And so we have the Safety Act, and that requires all reasonable precautions to be taken to ensure that people entering establishments are safe. And then we have the Occupational Health and Safety Regulation, and that requires employers to ensure that work sites are, as far as reasonably possible, safe for workers. So that's really the driving force which underlies the vaccine mandates, and which gives employers the authority and the ability to do these types of put these types of policies in place. Oops. Oh boy, it's a problem moving the slides here. There Okay. So yeah, we have as a starting point, occupational health and safety, which would suggest we very much need to put these types of policies in place to keep the workplace safe. And then as countervailing sort of considerations, we need to ensure that if we have these types of policies in place, that we are paying heed to privacy legislation and ensuring that privacy considerations are built into the policies as well. Because of course, vaccination status is private, generally private, personal, medical type of information. So to the extent that that is being collected as part of a vaccine mandate, which you would have to do, we need to make sure that employees know why it's being collected, what use is being made of that information, how it's being retained, if it's being retained at all. We need to have those types of considerations in our policies. And then the other piece of legislation, which is key in vaccine mandate considerations, is human rights legislation, of course. And the duty to accommodate. So there may be some cases where employees cannot be vaccinated, either for legitimate medical reasons or for a religious, based on religious belief. And those are the two main areas where we see exceptions being sought. And we'll talk a bit more about those. The grounds for them are actually quite narrow, but the policy, if you do have a policy, it does need to allow for this type of balancing consideration on human rights grounds. And we've made a note here as well about the Commission's statement. The Commission, NWT Commission, does have a statement on its website with respect to COVID-19 vaccinations. And of course, just saying there that we need to, of course, balance vaccination requirements with rights under human rights legislation. And just taking care to ensure that we're not having a disproportionate impact on marginalized groups when we put these types of policies in place. One other piece of legislation I'll just mention is the employment insurance legislation. And this changed in October of 2021, so very recently, to suggest that when an employee who refuses to be vaccinated, that's the reason that they've been terminated. When vaccination is made a condition of employment, they could be denied EI benefits. So it would be viewed in that case as the employee losing their job at their own hand. And in that case, in the normal circumstance, if that is the case, employment insurance benefits don't usually flow. So that's a new change we're seeing as well in the legislative landscape. So that's sort of the key pieces of legislation that factor into these types of policies. And I'm going to turn it over now to Tessa, and she will go through some of these more recent cases that have where we've seen challenges to vaccine mandates in the workplace, and what those cases are telling us.
Thanks. So hello all. We're going to dive into the legal challenges to the vaccination policies. And while we're not going to delve into the merits, what we're doing is looking at the decisions that have resulted from these legal challenges, as this kind of gives us a glimpse into how these policies will be assessed and the legality, validity, some areas of exposure in these sorts of policies. And right now, the cases that we're going to talk about are grievances, labor arbitration decisions. And those are the only cases that are currently have been issued, because arbitration is a much quicker process than the court process, which is where you'd see a constructive dismissal claim or civil claims. So that's why we haven't seen that yet. Of course, like the slide said, case law is still developing, and we do expect to see this percolate and the court weighing in. But as of now, what we can do is we can take a look at these arbitration decisions. There's some cases coming out of Ontario. We're going to look at a couple to see how does the arbitrator approach these policies and the balancing of rights between the employer and the employee, the safety of the workplace and employees' rights. And so right now, they've just been what are called policy grievances, which are a grievance challenged by the union to the policy overall, rather than a grievance with regard to a specific person and consequences that occurred to a specific person as a result of the policy. But it gives us a good lens, a good glimpse into are these reasonable? On what basis? What is going to be looked at? So we're going to first talk about the Ufcw and Paragon protection case. So this is came out November 9th. So as I said, it's actually good that we're doing this presentation now because we have these cases to talk about. Whereas before we were relying more so on cases that addressed flu vaccinations. And you'll see that there has been a differentiation and a recognition that flu vaccines and considerations around that is different than when we're in a pandemic situation. So in this case, the employees under the union were security guards. There was 4,400 employees. Sorry, I have a, excuse me, an inconvenient sneeze for you. So these were, 44 security guards, and they provided security services to clients at client locations. There's 450 client sites where Paragon Protection sent its workers to. And Paragon Protection decided to implement a mandatory vaccination policy. And as you see, that's kind of the long and short of the policy is on the slide there. Essentially, they said, you have to be fully vaccinated. So that's 2 doses by October 31. They did have a deadline for the first dose. And if they kind of told employees, if you haven't arranged for these appointments, you need to do so ASAP. And they were permitting some time off in order to obtain the vaccination, to go to an appointment. And so by October 17th, a week or so before that final deadline, the employees needed to provide a declaration confirming they have 2 doses of the vaccination. Now, an interesting and quite unique element of this case was that the collective agreement between the employer and the union actually had a vaccination provision. Now, this is very uncommon. The arbitrator actually suitably marveled that there was a vaccination provision in the collective agreement, which had been agreed to by the parties 5 years before the pandemic, when, the idea of a global pandemic was not even really in our comprehension. And that collective agreement provision did say that if an employee is assigned to a site, a client site, where the client, a condition of having a contractor in the client site was an inoculation or a vaccination of some kind, or where there's specific vaccinations required by law, the employee must agree to receive the vaccination or inoculation. So that's a bit of a wrinkle that we're not going to see in many other cases. But in this case, they instituted, in addition to that collective agreement provision, this mandatory vaccination policy. And like Isla said, they did provide for 2 exemptions. That was medical or religious exemptions. And employees had to apply for these exemptions on either health or religious grounds and provide information substantiating that request. And basically, if they had a valid exemption that was accepted by the employer, then rather than getting vaccinated, they were required to submit to testing. And the testing was at their own time and expense. And that's something that we're going to kind of talk a little bit more about, whether or not it is entirely kosher to, in an accommodation context, right? Because where there's a valid exemption, we'll talk about this more, you're getting into human rights and the duty to accommodate. So there is a question of, in the duty to accommodate context, can you make the employee pay money for their own testing, for their own accommodation? Now, even with the exemption, the policy still allowed Paragon, the employer, to place employees on unpaid leaves of absence where required, go to a different site, or participate in further testing requirements. So it was quite a aggressive and expansive policy by the employer, saying you need to be tested, and if you don't, we can take quite a variety of steps. And this, in our view, in our canvassing of the law, this is Canada's first decision on the merits of a mandatory vaccination policy. And because it was in the unionized context, there is a specific test called the KVP test to determine whether or not it can be upheld, the policy can be upheld. And the overall context is whether it's a reasonable policy. And so there's different elements involved in this test, in this assessment, and we have those up on the slides. But ultimately, what's important for our purposes is that the arbitrator in this case, I can turn this slide over, assessed the policy in accordance with the KDP test and ultimately found it to be reasonable and enforceable. And the basis for this was that the arbitrator, having looked at the context and those various factors, found the policy struck the correct balance between the rights of workers and the rights to a safe workplace. And he found that in this case, there was also an important aspect of the fact that the employees were being sent out to client sites, and company clients and members of the public were interacting with the employees in this circumstance. So in that sense, there was this added additional element of the employer ensuring a safe workplace that's also out of its hands, right? They're going to other people's workplaces. And so in this case, it was reasonable for them to take every precaution to ensure that safety was provided for in the various workplaces where their employees worked. And as Isla intimated, the basis for the legal basis or rationale for the ability to institute these policies was, again, in this case, grounded in occupational health and safety. This was the Ontario Occupational Health and Safety Act. And that was sufficient. The employer was trying to fulfill that obligation. So that was reasonable and proper. And the rationale in this case is helpful, but we do think that there are some limited application to this rationale, and you have to be careful about whether or not you can directly import the arbitrator's finding on the reasonability of this aggressive policy, and it's a mandatory vaccination policy requiring vaccination unless you have exemptions. This is entirely different than a vaccinate or test policy, which we'll talk about in a bit. And in this case, it's because of that client site interaction, the fact that they were sending their employees to other sites. And in this case, there was a collective agreement provision where employees had agreed to get vaccinated where required. Ultimately, the arbitrator did provide some good commentary that personal opinions about vaccinations are not going to ground the exemption. He made sure to differentiate between a valid exemption under human rights or protected grounds, or as the NWT Human Rights Act says, prohibited grounds, and just personal opinions. That's not going to be able to outweigh the employer's obligation to keep a workplace safe. And as I mentioned, prior to these cases, the other case law that was milling around about mandatory vaccinations was flu vaccinations. And in this case, the arbitrator said, okay, I see some parallels, but this is entirely different. Dealing with flu is different than a pandemic situation and a situation of COVID-19 with its with the evidence showing it's highly infectious. So there's limited application of those policies, and those policies weren't entirely supportive of mandatory vaccination. And to differentiate the pandemic from those policies or those cases, he did quote from the Ontario Chief Medical Officer and the Human Rights Commission. And the medical officer intimated that there's going to be much less exceptions, right? An actually valid medical reason for not getting a vaccine will only occur in limited circumstances of severe allergic reactions or quite rare heart conditions. And the Ontario Human Rights Commission also had sent out a statement saying essentially personal preference is not a valid exemption. So that's the first case. And we want to contrast the Paragon case to the next one, which was issued days later on November 11th, also from an Ontario arbitrator. And in this case, you'll see it's a very different work environment and the resulting differences in the rationale and whether or not the policy of mandatory vaccination was reasonable and could be upheld. In this case, it was also mandatory vaccination. There's 414 employees involved. And essentially they were required to be fully vaccinated by a certain date or face discipline, including termination. So similar to the Paragon policy. But in this case, the arbitrator looked at and differentiated the facts of the scenario to Paragon by saying, you know, without that collective agreement provision, we don't really have a precedent of employers saying you have to be vaccinated unless we're looking in a situation where the workers are dealing with a vulnerable population, such as a healthcare setting. So, you know, when we don't have that case, that law precedent saying outside of a vulnerable population, mandatory vaccinations are valid, and without the legislature weighing in, there's going to be some real problems. And so the arbitrator in this factual context applied that same KBB test and looked at whether or not it was reasonable, given the health risks in this specific workplace, to institute a mandatory vaccination policy. So he differentiated this workplace. There was not dealing with clients of a vulnerable population, such as, you know, seniors or people in hospitals or what have you, and found also that the certain facts of this case, and the arbitrator was quite specific and really reliant on the facts, showing that in this case, the workplace, there had been no COVID outbreaks, very few confirmed cases of transmission. The employer hadn't engaged in an analysis of the dangers associated with their concerns or the feasibility of remote work from home. There was a very high vaccination rate already. Only 14 employees had disclosed that they had not been vaccinated. And there was no prior regime with a testing option. So he really focused on the facts and kind of was saying to the parties here, mandatory vaccination, which is on the, you know, the furthest end of the spectrum, it's not a mandatory or test, saying everyone has to be vaccinated to work with us, was not reasonable in the circumstance when balanced against the employee's right to bodily integrity and their choices. And in this case, it was because of the facts. It was because, you know, the low transmission rate, and then also the fact that there hadn't really been an exploration of whether or not it could be a vaccination or test policy. And we do know in this case, the employer, we're not trying to kind of lay blame or anything, but the employer didn't really provide a fulsome evidentiary case. They provided their concerns about transmission and COVID generally, but didn't provide sort of an evidentiary basis to say, this is the assessment we came to, this is the evidence we have on transmission and on the risks. And so in this case, it was held to be unreasonable. But the arbitrator did acknowledge that, as it says on the side, it's a fluid analysis. This was depending on the facts. So if the risks changed, you know, at this time, the arbitrator found the risks to be very low in the workplace. If the risks change, then a policy could be reasonable. And similarly, basically, mandatory vaccination wasn't required, but something short of that, like a vaccinator test, could be more reasonable. And so this next case, the Ontario Power Generation and Workers Union, this involves a vaccinate or test policy. And this decision was issued also on November 8th, so a day before the very first one. And the policy required either people to be vaccinated or unvaccinated employees were required to do rapid tests, 2 per week, and then upload proof of the negative test. And here the employees are covering the cost. The tests had to be done on their own time. And if they did not test and were not vaccinated, they could be placed on unpaid leave. And then after 6 weeks, they could be dismissed for cause for failure to be vaccinating or failure to test. So in this case, the arbitrator had to look at a policy that was not quite mandatory vaccination. It was a bit more fluid. So it wasn't saying the only way you could not be vaccinated is if you have a valid human rights exemption. It was saying, okay, you can have a personal choice, but you need to be tested. And in this case, that was reasonable. Testing unvaccinated employees was reasonable in the circumstances. Now, it is notable that the arbitrator found that in this case, the employer should pay for the testing. Now, he connected this to the employer's obligation to ensure the workplace is safe and threaded that through to the idea that to do so, they need to pay for the testing. Whether or not that can be applied to every scenario, I think is questionable. But it was an element in this case that this employer had the capacity to and the obligation to pay for that testing. However, it needed to be done on their own time. And in this case, the arbitrator also upheld the fact that the failure to comply, so the failure to test and upload and what have you, or get vaccinated, that was reasonable. So you could take disciplinary and ultimately terminate employees if they refused to participate in reasonable testing or and then essentially attend work in a fit manner. So that was entirely appropriate given the circumstances. Now, there was this also added element, which was interesting. There was a company gym, and the employer, as part of this policy, said, you know, if you're unvaccinated, you can't attend because it is a high risk area with touching and breathing and what have you. So that was another added element. So the idea that you could be just tested, but unvaccinated, that didn't apply to the gym, and that was reasonable. So you see kind of a bit of the two sides to a mandatory vaccination in those first two cases, and then the Ontario Power case, which is the more down the middle approach, which is a vaccination or test, and the elements that decision makers will look at to find if they're legal and reasonable and can be upheld. So this is kind of workplace, context, transmission, risk, and then obligations placed on the employee as a result. So I'll hand it over to Isla to talk about constructive dismissal.
Thanks, Tessa. So what Tessa has gone through, of course, is a number of cases that arose in the labor arbitration context, so in the unionized work environment. So we've seen in the unionized work environment, if an employer puts a policy in place, it will be analyzed against the KVP test that Tessa mentioned. And of course, that requires a balancing of a number of factors. But we also need to consider the non-unionized work environment. So if you're working in a non-unionized work environment, how do we analyze vaccine mandates in that context, and what's the law that applies there? So we haven't seen any that we're aware of yet, any specific direction from the courts on this type of issue, because if an employee is terminated or is put on unpaid leave in the non-unionized context, likely what they would have to do is bring an action for wrongful dismissal, either constructive dismissal or if they were terminated, an action for wrongful dismissal. So we would see direction from the courts there, but still to come. So how we would analyze it is, I guess, in the context of what's called constructive dismissal. So constructive dismissal can arise where an employer makes a unilateral change to what would be considered a fundamental term of the employment contract. So if they change duties or pay or something that's fundamental to the underlying terms of employment without the employee's consent, if they just do it on their own, that can amount to constructive dismissal. So for example, if someone made $100,000 a year and the employer unilaterally reduced their wages to $50,000 a year, we would say that that's no longer what the two parties bargained for in terms of the employment contract. And so even though the employer hasn't actually dismissed the employee, in taking that step, they have effectively dismissed the employee. And so that's how constructive dismissal works. And in the COVID context, we look at it and say, does a requirement to vaccinate, is that a unilateral change by the employer to the fundamental terms of the employment contract? And so could an employee say, if you're requiring me to get vaccinated, can I say you've fundamentally changed my employment contract and I can now assert constructive dismissal? So that's still an open-ended question. I think how we've sort of conceived of this issue is, well, the employer could say, no, we have this obligation to keep the workplace safe. So we're not actually changing the terms of your contract. We've always had the obligation to keep your workplace safe. That's always been a term of our agreement. And we're responding to a new threat to the workplace, COVID. But so that's what's new. It's not that we're changing the terms of the employment contract. We're just responding to this new hazard and new threat to the workplace. So that's, I think, one way to conceive of it. And as a part of the employer doing its job on that front, it's put in a vaccine mandate. And so it's not constructive dismissal in that sense. So that's, I think, one of the key defenses to these types of claims. Yeah, those are the obligations set out there. So the other question then is, if an employee is placed on unpaid leave as a result of failing to comply with a vaccine mandate, could that amount to constructive dismissal? Because in that case, the employer has taken away the employee's duties, essentially, right? So the employee is not performing work anymore and not being paid. And so is that a fundamental change to the terms of the employment contract? And I think at first blush, you could say, yes, it is, except again, the reason the employee is not in the workplace is the employer responding to the employee's refusal, I guess, to comply with vaccine mandates or testing options potentially. And to that extent, they are no longer safe to be in the workplace. And so the employer has put them on unpaid leave because they are no longer safe. And the employee can rectify that by becoming safe. And so it's a question whether that's really a unilateral move by the employer. I mean, the employer has to do that to keep the workplace safe, and the employee can change those circumstances just by taking steps to either vaccinate or test. So I think it's, it is arguable that it is not, would not amount to constructive dismissal in this circumstances. So we'll move now to just talking about some general considerations for vaccine mandates in the workplace. And as Tessa pointed out, going through these cases, the workplace setting will play a significant role or may play a significant role in whether or not an employer can successfully defend a vaccine mandate. Initially what we were thinking is for sure in the healthcare settings, and you saw that arbitrator in the one case say, I haven't seen this try to be put in place outside of the healthcare context, or in a workplace where you're caring for children who are not yet able to be vaccinated, vulnerable populations, or if you're in, even a construction work site where people have to be, by nature of the job and for safety requirements, they have to be right close together and working close together, possibly touching each other, then in those types of work sites, there may be a better chance of having the policy viewed as reasonable. And so again, like it's saying here, can you consider an alternative to vaccination? Can you give an option to test? So that if you have that built into the policy, it may be viewed as more reasonable overall. It's interesting though, because in that one case, the electrical safety case that Tessa mentioned, the employer was concerned because there was no evidence from the employer about, what the impact of the hazard in the workplace. So like, what were the infection rates, or, if we don't have this vaccination policy, what's it going to look like, or have other steps been taken to keep the workplace safe, like just masking or social distancing, why is that not effective in and of itself? So that's interesting, because we've seen other cases that have seen where the arbitrators have said, we don't really need to see that evidence because we all know that COVID is a highly contagious, new novel virus. We're still, don't know sort of the long-term impacts, or it's still all very new, and we're learning about it day to day. So just that, we know that if it presents in a workplace, that it can spread quickly. And so that creates obviously a big safety risk in the workplace. So just having that information may be enough, for the employer to say, no, it's a highly contagious new virus, and we need to put in measures to protect our staff. We don't need to wait until there's been an outbreak and show you, yes, there's evidence of the need for this type of policy. So, because this is all so new, arbitrators are working through it and lawyers are working through it, and, people may have different views and thoughts on it. But certainly, if there is an element of vulnerability in your workplace, of caring for vulnerable people or a higher risk population, then there may be a greater chance of upholding it. Yeah, so if there is a testing option, the benefit of that as a backstop to the vaccination is, then there's not a requirement that you vaccinate. There is another option to vaccination. So that means that, there is an out for those who aren't willing to sort of undergo vaccination, or, that it kind of addresses the bodily integrity type of argument that we hear from time to time. So the question, I think that's still a bit of a hot button question out there too, is who is required to pay for the cost of testing? And in that case, the last case that Tessa talked about, the Ontario Power Generation case, there was a direction there that the employer pay for the testing, but that the testing could occur on the employee's own time, could and should occur on the employee's own time. And the employer did not have to pay the employee for that time that they were doing their testing. So that was kind of the balance struck there. They had to pay for the test and the process that went along to report the testing results, but they didn't have to pay the employees for the time. So this question comes up a lot. On one hand, you can say it's the employer's requirement that you test, so that the employer should pay for it. But on the flip side, I think what you could say as well is, well, no, it's the employer's requirement that you vaccinate. And if you're refusing to comply with the employer's requirement, they've offered you an option. But, because you won't comply with the gold standard and you want to do this other thing, well, then maybe that burden should be on you to pay for the testing. Because it's not really that the employer has asked for testing, they've asked for vaccination. So, if you're not willing to comply with what they've actually asked for and what is, widely regarded as the gold standard, then maybe it is fair to put that burden, the cost of testing, on employees. And we're seeing really different approaches for a lot of clients in what they're doing in terms of paying for that or not. It can be very expensive if you have a lot of employees doing it and on a very regular basis. So that is one of the sort of issues that's out there percolating. And we have this one case that talks about it in the unionized context. So that's maybe some direction that the employer should pay, but I think there are also arguments on the flip side as well. So, and then of course there's administrative burdens that go with the policy, especially with testing, if having to be frequently being supplied with the test results. Of course, vaccination is more of a one-stop one-stop option. You can just have your employee provide the vaccination confirmation of vaccination, and then you're done. So it's a lot easier on that front as well. The one little caveat I'll put on the cost of testing analysis is that if someone does present with a reasonable accommodation or a reasonable human rights reason why they cannot vaccinate, and that's you've gone through the analysis and you've accepted that there is a human rights reason for the employee not to vaccinate, then you will need to provide an accommodation. And if that accommodation is testing instead of vaccination, then the employer should pay for it in the context of accommodation, because the employer is expected to provide for and pay for accommodation. So that's one case where the cost of testing is a little more clear, is where it's offered as an accommodation. So when some of these vaccination policies were initially put out into the world and announced, we had a number of unions come to the forefront as well and say, look, we're going to support these policies of the employers for good reason. But they did say, we will support them if they are, taking into account a number of things. Do they provide for the human rights exemptions? And do they start sort of from a position of looking at non-disciplinary responses to non-compliance first? And so that's one thing we've advocated as well, is can you start with a non-disciplinary response and go from there? So there are other alternatives, like for example, if someone won't vaccinate, can they do their job from home? So that's one option, but the difficulty with that is many workers across the country, of course, as everyone's been working from home for a good chunk of the last 2 years, have found they've enjoyed working from home and would like to continue working from home. So if it's actually viewed as a a good, you're getting rewarded for not vaccinating, then that's maybe not the best way to go, because it could act as a disincentive to vaccination. So I think that type of option would need to be considered carefully. Certainly it could be offered as an accommodation, again, if we have a valid human rights exemption, but generally I'm not sure if it's the best option in terms of, incentivizing vaccination. The most common response we're seeing, of course, is non-disciplinary leave without pay, so unpaid leaves of absence. And so that's what I think most policies are contemplating. And then, but discipline and termination can still be defensible. We'll talk a bit more about that when we talk about enforcing the policies. This is a key point as well, and Tessa mentioned it, and she was echoing some of the comments by the arbitrators there. COVID we've been through 2 years of rapid change, and our knowledge is growing day by day. And so I think policies need to be, most policies that we've seen, employers have built in a 6-month, at least every 6 months, the policy will be reviewed. That makes good sense, so that we can ensure that any policy is compliant with current public health directives. And as is noted here, as your workplace gets closer and closer to 100% vaccination, then you can have a mandatory vaccination requirement for new employees, perhaps, and you just have to sort of rejig and consider where we're at and the overall health risk. If we're sort of getting to a point where we're returning to normal, and the health experts have told us, no, we have sufficient herd immunity out there that our healthcare system can withstand COVID now, and we'll all be okay, then again, we need to revisit and see if it makes sense to still have these policies in place. Sorry, oh, there we go. Okay. Privacy, we've talked about as well a little bit. I think the key points here is, if the policy is overall reasonable, then of course requiring an employee to disclose vaccination status as part of that policy will likely be viewed as reasonable as well. I think the things that just need to be considered there is that employees have to be made aware of what you're going to do with the information you've collected about their vaccination status. So what use will you make of it? Will you disclose it to anybody else? How it will be used? All of that needs to be made clear to the employee. And what we're also seeing is often what employers are doing is just asking for someone to show proof of vaccination. So you can just show your employer your vaccination records, and then the employer will make a note of it without actually retaining any of the underlying documentation. And that makes a lot of good sense, because then the employer doesn't have copies of your records. You're entitled to keep those as an employee and keep them out of your employer's hands. And then the employer doesn't need to take additional steps to ensure that everything is properly safeguarded and retained and doesn't get into the wrong hands or anything like that. So that's one way to do it. Other things we've seen considered is, anonymous surveys in your workplace to assess vaccination rates. So you could ask people to anonymously respond to surveys just to get a sense of where your workplace is at in terms of vaccination rates. So that's one option as well. And then that will give some guidance in terms of whether you feel you need to actually have a policy in place at your workplace. Yeah, and so we've talked a bit about enforcement as well. This is, putting the policy in place is the easy part. Enforcing the policy is definitely the most challenging. What is the best approach to take? And like I've seen, we've seen more support from unions and other people, and employee side counsel, if it's sort of starting with not a disciplinary approach and kind of gradually going up the chain as is needed. So the one thing I will say is that we've talked a bit about whether the unpaid leave of absence could amount to constructive dismissal, and there's kind of arguments on both sides. Termination of employment, it can be done, as you will have seen in the Ontario Power Generation case. The arbitrator used quite strong words in that section, basically saying, look, where you've got an employee who will not test and who will not vaccinate, and you put them on unpaid leave and give them 6 weeks to think about coming into compliance, then, most likely you can terminate them then, because the arbitrator was saying, like, look, we're in the middle of a global pandemic and you won't do your little part to ensure that everyone else is safe. And so, that in that case, there's a high likelihood of the termination being upheld. In the non-unionized setting, it's actually a bit easier if you're terminating someone without cause, because the general rule is we can terminate anyone without cause, subject to human rights considerations. But so if you just give someone the required amount of severance, you can terminate someone, and whether that's for non-compliance with the vaccine policy or not is neither here nor there. You do have that right as an employer to terminate without cause and pay severance. And in that case, if you've done that and paid the right amount of severance, there shouldn't be any concern with that course of action. The more challenging area would be if you were to terminate in the non-unionized setting for cause, and just say, we're terminating you because you won't comply with the policy, and we're saying it's for cause. Then you would have to get into, the whole, is the policy reasonable? Did you have did the employee fail to comply? Like, were you given opportunities to comply? Like, going through the whole sort of, showing that the vaccination policy was reasonable and that the employee didn't comply and that this amounted to just cause. So in the non-unionized setting, if it's reasonable, to pay severance, if it's not, if it's contractually stipulated, or if the severance amount is not, going to break the bank or something like that, then that may be a good option as well. So we've talked about, of course, putting the policy in place, and now we're going to move, just got 10 minutes left here, but to address exemptions to the policy, and do we ever need to make exemptions to vaccine mandates? And like we've said, we do need to have it built in so that there are options for employees who may have valid medical reasons for exemptions, or who may need to, may have religious beliefs that prevent them from being vaccinated. This has proved to be one of the most challenging areas for employers as well. And in assessing these requests for exemptions, determining whether they're valid, is there sufficient documentation to support them? Very, very challenging area. And certainly with medical accommodation, what we've sort of seen in the case law, and Tessa will mention a case in just a minute, where it kind of said, maybe in this case, this prescription pad type of information, like so-and-so has a medical condition that means they can't vaccinate, won't be sufficient. And I think that's particularly because we have seen colleges come out, for example, the College of Physicians and Surgeons in Alberta, and they have said really there is really no universal medical condition that would prevent vaccination. So it's really your decision to say, as a physician, if you're going to say someone should be exempted on medical grounds, it's got to be evidence-based. And there may be a valid reason if somebody has reacted to the vaccine. There's some cases of the myocarditis that would maybe suggest someone else shouldn't have a second dose of the vaccine, or things like that. But they are very, very narrow grounds. So I think what we really want to see is a clear medical basis why the vaccine is contraindicated. So I think those will be very, very few and far between. Religious accommodation is an even thornier area because it's very difficult as an employer to sit there and say, yes, you have a valid religious belief that you shouldn't be vaccinated, or no, you don't have a valid religious belief that you should be vaccinated. And this is very difficult and to assess. And when Tessa will mention a case in a minute where we have seen some commentary by the Alberta Human Rights Tribunal on this issue. So that's been very helpful. At the end of the day, really what you need, really the analysis comes down to this, is an employee can't come to you and say, I believe I shouldn't be vaccinated, and I'm a religious person, and therefore I have a religious belief that I can't be vaccinated. That's not sufficient. It has to be a little more rigorous than that. And so what the cases are saying are, the individual must provide a sufficient objective basis to establish that it's the belief is a tenet of a religious faith. So it doesn't have to be universally held by all in the religion, but there has to be some nexus or some connection to the overall belief system that the individual belongs to. And human rights commissions across the country have made clear that personal preference or a singular belief, this isn't going to engage human rights protection on the basis of religious grounds. So it's not just, again, I am a religious person and I believe this. That's not going to meet the threshold. And we have seen, as in working with our clients, a number of what we will call, I guess, the internet letters, right? Where somebody can go to a website and just put their name in and they can produce this boilerplate letter from, a religious organization of some description. And we've seen a number of these same letters come across our desks over and over. And often those, raise some flags just because they are not specific to the employee themselves, right? They don't have the, it's not that we're getting a letter that's personalized from the religious leader. And so on those, we've certainly encouraged employers to push back and seek more information about, how long you have had this type of belief, or how does it infuse your daily life? And we've seen a lot of objections to the vaccines because they use these fetal line testing things, and these people are rejecting to the use of fetal tissue or objecting to that use. But this type of testing is commonly used for a lot of other types of medications. So, Tylenol and Pepto-Bismol and day-to-day types of medications. So if the individual uses those types of medications, then, it sort of calls into question how serious this belief is about being against fetal line testing. So it's full of thorny issues. We're all trying to work through it together, but I'll just leave it to Tessa now to speak briefly about the Peltier case, because that does provide us a little bit of guidance. This is a masking case, not a vaccination case, but it was the objections were based on physical disability and religious grounds. So it is an instructive case.
Wonderful. Sorry about some screen tampering accidentally. But yeah, as Isla said, this was a fairly recent case that just came out, and yes, definitely about a masking policy, but I think that the line of analysis on the evidence, or how do you substantiate a medical and or religious claim, and therefore exemption to a requirement such as masking or vaccination, is quite helpful. So in this case, it was a fellow going into a business, this is a Community Natural Foods, and he said essentially he was being denied the service and hadn't been accommodated on the grounds of physical disability and religious beliefs because he was required to wear a mask. And I just wanted to note, when we talk about medical exemptions, we're talking about disability. The prohibited ground under the legislation talks about physical or mental disability. That's where medical exemptions will fall under, versus religious, which is just religion or creed, depending on which legislation you're under. So in this case, he basically said, yeah, I have a medical condition and a sincerely held belief that I should not be required to wear a mask, and hopefully I can move the slide. Here we go. So we're first going to talk about the medical, and then we'll move on to the religion. But this slide gives you some context of what his argument was. So he basically said he had a condition, and then with regard to his religious belief, he contended that this would related to the premise that God created humans in his own image, and therefore, if God cannot see his image, his face in Peltier, then there was sacrilege committed. And so this did end up going to the Human Rights Commission, and a tribunal ruled on it. And with regard to the medical exemption, the tribunal chair found in this case that sort of prescription pad, very brief, very minimal information was insufficient to ground the claim that he could not wear a mask and therefore required accommodation. His medical note basically said he's medically exempted due to a medical condition. So there was no information. And the tribunal looked at this and goes, we need something more. So we need confirmation of a disability, because that's the protected ground, the nature and scope of it, and what restrictions arise. We need to see that connection from disability to inability to comply with this requirement, which was to wear a mask. And I think what the parallel you would draw is that same sort of causal link, causal connection between disability and inability to vaccinate will be required to get that accommodation and substantiate that it's necessary for you to be accommodated based on a medical exemption or a disability. And so the tribunal stated that there has to be more information required. And so it was dismissed on that ground because he didn't have sufficient information. Then they moved on to the religious exemption, and the same thing was there. There was insufficient evidence that he had a religious belief that substantiated the inability to comply with the requirement to wear a mask. And this is helpful in the sense that, as Isla said, it is thorny. It is a difficult thing to tease out. Okay, well, we don't accept just personal beliefs, but we don't require it to be kind of a mainstream fundamental belief. It's something in between. So what are we looking for? And the tribunal found that in this case, there was not enough evidence because not only could Peltier not actually identify what religion or faith he followed, but he couldn't provide that connection between his faith and the belief that he could not wear a mask. So he did quote from a couple books of the Bible, but they were not related to face covering. And then he also couldn't demonstrate that connection, that his inability to wear a mask was a faith-based belief. And this is important. Basically, while he wasn't required to be part of a mainstream religion, while it didn't need to be a mainstream belief, he did need to show that there was a belief tied to a religion that required his face not be covered. And so there's kind of a pithy quote there at the end saying, essentially, you need to do more than just identify a belief, claim it's sincerely held, and claim it's religious. There needs to be that objective basis for that finding. And I think that's important and helpful direction from the tribunal in the sense of what are we looking for as an employers to say this is a valid religious basis, and therefore I need to accommodate you under my policy. So that leads it to essentially, this all ties into the duty to accommodate. So if you have valid protected grounds that restrict you from being able to be vaccinated, then this implicates the duty to accommodate someone's protected grounds. So you can't just hold them to the same standard anymore. So you have to take alternate measures. So examples of accommodation, and accommodation is always very fact specific, depends on your workplace, your abilities, as well as the employee. Examples include working from home, changing assignments, testing could be part of it, as we've talked about, but of course, it's likely that you'd have to pay for testing unless you can establish that that is kind of an undue burden on you. And that's because the duty to accommodate is only to the point of undue hardship, which is essentially the idea that, that's sort of a contextual argument, but you're not required to go out of business in order to accommodate one employee. It's a reasonable accommodation. And so those are some examples of some reasonable accommodations. And yeah, just finally, a reminder, vaccination status in and of itself, I'm an unvaccinated person, has not yet been, that's not a protected ground under the Act. So you have to ground it in, I'm unable to because of a medical condition or religious belief. So it's quite a lot of information that we've thrown at you, but it is a thorny subject with some guidance. So if you have any questions for Isla and I, we'd be happy to do that. So if anyone wants to, you're welcome to put up your hand or unmute or put it in the chat. We might not have any questions. Oh.
So one thing that we're seeing, and it's a little bit different than employee-employer relationship, is that our clients, primarily the governments, are now downloading it onto business to enforce vaccination policies. So it's like, unless you're 100% vaccination, so now we're mandated to do vaccination policies and collect information. Otherwise, they will terminate contracts with us or not award work, even though we don't actually send employees into their facilities. So is that, and it puts us in a situation where our clients are saying you need to have 100% vaccination, or employees have to go through twice a week testing and wear PPE. But all of our work has been remote with them. So, but they're forcing us to sign these legal type letters saying that, oh no, we've got 100% vaccination. So, how do we balance that versus our employer-employee relationship?
Yeah, that's a tough one. We've seen similar things here. I know, Alberta Health Services are big, health services for the entire province. If you're a contractor to them in any way, they've put similar requirements on their service providers as well. But I think there's are limited to situations where the employees actually interact with an AHS staffer. So there's I guess a bit more connection than what you're describing here. I mean, it is difficult because that's, I guess, sort of a contractual relationship, and they're now saying as part of the contract, this is what you need to provide, right? Is 100% vaccinated staff. The difficulty though is like we've said, is where a policy is just 100% vaccination, like you have to be vaccinated and there's no off ramp with test. That's going to be potentially harder for an employer to uphold. So if they're putting you in a position where you can't provide that guarantee, because some of your workforce may be testing. I mean, is there any flexibility there? Are they saying vaccinate or tested employees, or is it just vaccinated?
No, they're saying vaccinated or tested.
Tested, yeah. Yeah, I mean, that's, it's tough to know. It's reasonable in the sense that they're just asking you to comply with what they're asking all their own employees to comply with, right? So, and conversely, it's not unreasonable for you to ask your own employees to comply with that type of a policy in the context of the pandemic. All I can maybe advise is some conversation with them. Like, is it a struggle for your workplace because you don't have employees in those categories, or is it just it's too much because you're just working remotely?
Well, here's maybe a more basic fundamental question. Can we even ask our employees what their vaccination status is?
Yeah, you can, if it's part of an sort of initiative to keep the workplace safe, and as ensuring that you've got compliance. Like, you can say to employees that we are now mandated by the government or by another organization to have this in place. So we are going to, as part of complying with this, ask for vaccination status, and because our employees have to be either vaccinated or tested to work on these contracts, for us, something we need to do now. So we're going to put this policy in place.
Okay.
Are you in a unionized setting, or?
No.
Yeah.
No.
Yes, a little easier to work in that context. But yeah,
Okay.
it's
Thank you.
Sure. Probably overloaded everyone with information today, but yeah, I know we're past time now, but certainly Tessa and I are happy to stick around for a bit if there's any other questions.
Can I ask one more question? It was one of your later slides when you said as you get closer to 100%, I think it says it's harder to defend mandatory vaccination. I was just wondering, why does it get harder to defend mandatory vaccination the closer you get to 100% vaccination?
Yeah, I think that's maybe more in the context of as close as we as a society get closer to 100% vaccination, and if the health advice is now, okay, yes, we've achieved herd immunity, and we'll be able to sustain our healthcare systems and everything's okay now, then it may be harder for us to defend these types of policies, just because the world has gone back to normal, kind of thing, and it's right now it's very much not normal, and we can say that there's a very sound basis to have them in place. But if we moved away and the health advice was okay, everything's fine, then it'd be less reasonable potentially to require employees to get vaccinated as part of an employment condition.
I think it goes to risk. Right now, these policies are responding to risk and how that risk impacts your employer obligation to provide a safe workplace. I think there's a live question is, if the risk goes away, can you still maintain what might be seen as more onerous obligations? So I think that's kind of a little bit more. And that's why we talked about flexibility of policy, because this is a policy in response to risk rather than I'm not sure that it necessarily, and we'll have to see where the law goes, signals a shift in the law that now these are just generally sound.
If I may, please, you've covered quite a lot of ground, and there's a lot of legal stuff here. So forgive me if I'm asking you a very primitive question, but the primitive question is, how does this vaccine mandate and requirements intersect with the charter rights?
So charter rights are implicated where it's a public act, a government act, that impedes on those protected individual rights. So as of now, there has been no legislation mandating that. So we're not really in charter territory. However, if a government does enact legislation, then that's where kind of charter rights would be implicated.
Thank you.
No worries. It's not primitive.
Looks like there's no more questions, but thank you so much for your time today. I know your time is valuable. And this presentation, for those of you who you know of others who were interested but weren't able to join today, or you want to go back over it, because there's quite a bit of material covered, I'll be posting it on the Chamber of Commerce website. I took a video of it, so it'll be up there if you need to reference it, you want to go back and take a look at some stuff. But otherwise, thanks everyone for joining us, and thanks so much to our speakers today.
Thank you.
Thank you.